Our speaker today is Vaughn Westheimer. He's a member of the Unitarian Universalist Church of Corpus Christi. He is mostly, but not completely, retired attorney, as well as a poet and a short story writer. Vaughn and his wife Amelia are parents to 4, or possibly 5, cats. Please welcome Vaughn.
Good morning. We say that greeting every week and several times today already, and I truly hope you have a good morning and a good rest of your day and good times always. But things happen that can mess up our days even if we try to keep a positive attitude. For instance, say you're at the zoo. Below you is the gorilla habitat. You want to get a better look at it, so you climb up on the wall, but you slip. And you fall into the gorilla enclosure, and you break your arm and fracture your skull, and you're knocked unconscious by the 20-foot fall. And you were in there with real gorillas. Now, I'm pretty sure this has not happened and will not happen to anyone here, but it did happen to a 5-year-old boy who was visiting the Jersey Zoo with his family on holiday in 1986. More on that later. For clarity in my presentation today, I will be using the word animal to refer to non-human animals. Here are some statements regarding our relationship with animals. From chapter 1 of Genesis, the 1985 translation by the Jewish Publication Society, and God said, "Let us make man in our image, after our likeness. They shall rule the fish of the sea, the birds of the sky, the cattle, the whole earth, and all the creeping things that creep on earth." Note the verb rule. Now from the 8 principles of Unitarian Universalism as they appear on our U2C3 website. Here's the 7th principle. We must care for our planet Earth, the home we share with all living things. So this statement has the verbs care and share. And from the Unitarian Universalist Association's website, the 7th principle, respect for the interdependent web of all existence of which we are a part. Respect is used as a noun in that sentence, but it's also a verb. I submit that UU principles call on us to respect and care for animals in this world we share with them, not man apart. The covenant we recite includes the words to serve human need. You know what? Animals serve human need. We human beings put animals to work for us frequently. Dogs, horses, oxen, and elephants are among the animals with a long history of serving us. We even have a term for some of them, beasts of burden. Others, as I will talk about later, are called service animals. Besides working for people, animals also give us comfort and companionship. And we do things for them as well, such as providing food and shelter and veterinary care. It is a fitting extension of the. In a little while, I will be talking about the needs of animals. In a little while, I will be talking about some of the laws protecting animals as well as other laws dealing with relations between humans and animals. I'm not trying to act as a law school professor and turn you into experts in animal law, but I hope to give you a feel for what the law can do. I'll talk about the current state of the law, but I need to point out that laws can change. Also, they can be interpreted in different ways by different judges, and a slight difference in facts between 2 similar cases can lead to different results. So if you have a legal matter arise that involves something I talk about today, you should seek advice as to how the law as it exists at that time applies to your situation. My presentation today is not intended to create the attorney-client relationship, and it's not intended to provide legal advice as to any specific case you may have, and there's my obligatory disclaimer. Okay. About 66% of U.S. households have pets. 32.5% have cats, 45.5% have dogs. Those numbers add up to more than 66% because some homes have both cats and dogs. Incidentally, fish come in third at just 2.9% of households. How many of you have at least one dog or cat? Lots of hands. Um, How about other species of animals that you intentionally have living in your home? So you don't count mosquitoes. I'm sure many of you consider them family members. That's how we think about our 4 or maybe 5 cats. You might not regard your animal housemates as property. You might not use the word pet to describe their status. Under Texas law, however, animals are property. Some animals are a special kind of property under the law in that there are rules that apply to them that do not apply to other types of property. For example, if you get mad at your television, you can smash it with a baseball bat. It's your property to abuse if you are so inclined, but you can't treat your cat, dog, or other animal you own like that. Our covenant to dwell together in peace should include our relations with non-human members of our dwellings. Our covenant starts with love is the doctrine of this church. Considering that in conjunction with the principles that I quoted before, I feel that that line of the covenant applies to our animals. And I will tell you that we love our kitties, and I think most pet owners feel that way about their animals. While I can't say that emotions felt by other species are exactly the same as human emotions, I will say that we receive some form of affection from our cats, and I know dog owners will confirm the same from that species. Birds, oh, yes, I'm sure loving birds. And my wife is a former bird owner, so there are I'll talk about specific laws now. There are multiple sections of the Texas Penal Code making cruelty to animals a criminal offense. There are separate sections dealing with livestock animals, non-livestock animals, and assistance animals, but in each case, the offense in some circumstances is a felony. There are a lot of subsections in the statutes, and I'm not going into all the details, but the point I want to make is that Texas and presumably all other states take a serious view of cruelty to animals. Texas law makes it an offense to engage in dog fighting and cockfighting. Those can also sometimes be felonies. Some of you may be familiar with former football player Michael Vick, who was convicted and sentenced to prison for dogfighting activity that led to the deaths of several dogs. He later commented that he hoped to own a dog someday, leading Conan O'Brien to quip that dogs responded by saying, "Meow." I don't know if Vic ever got a dog, but in Texas, it is against the law for a person convicted of cruelty to non-livestock animals or convicted of abuse of an assistance animal or of dog fighting to possess or exercise control of an animal within 5 years of the date after he or she was convicted. This is a misdemeanor, but not a felony, but it can result in jail time for a second offense. The Texas Family Code has provisions for protection against family violence. The category of who can be protected by a protective order is broad, including even someone in a dating relationship or a former member of the household of the person applying for the protection. While animals cannot apply for protective orders, they can be protected. Specifically, the Family Code says that the protective order can prohibit a person found to have committed family violence from harming, threatening, or interfering with the care, custody, or control of a pet, companion animal, or assistance animal that is in the possession or care of the person protected by the protective order or a member of their family or household. Texas had a protective order statute since 1979, but the protection of animals was not added until 32 years later in 2011.
I have a question, Mr. Lawyer. My cat a lot, likes to roam around outside. He's got cat class. He's got cat style, you know. Anyway, lately, some creepy guy got out of his vehicle and called out to Prancy, even tried to catch him. I yelled at him to leave my cat alone, but he still comes by. Is there anything I can do about this?
Yes, the Texas Penal Code and the section on stalking includes a provision that it is against the law for a person to engage in activity on more than one occasion that the person knows or reasonably should know that another person will regard as threatening the other person's property. The statute specifically states, for the purposes of this section, property includes a pet, companion animal, or assistance animal. So stalking an animal is illegal in Texas. You can report them to the police. How are animals dealt with in divorce cases? Since they are property, the judge can award an animal to either spouse, just like the judge can do with cars, furniture, real estate, and every other type of property. The parties can agree on orders, but if they don't, then it's up to the judge to decide. One option is for the parties to be co-owners. There could be essentially a visitation schedule and an order involving expenses for the care of Cat Masterson or Dog Holiday. However, if one of the parties fails to make support payments as ordered, the order cannot be enforced in the same manner as child support. With child support, someone can go to jail for contempt if they don't pay. In most circumstances, a person can't go to jail for not paying animal support. Also, if circumstances related to the parties or the animal change, the court cannot modify the order, as can be done with orders involving human children. A final property division can't be modified, only clarified.
Attorney Westheimer, I'm a wealthy Texas widow, and I would like to leave my vast fortune to my precious cat, Kitty Galore, and my dear dog, Barbarella Beagle. Can I do that?
Sort of, and I'm glad you're able to pronounce my last name correctly. Here's Texas law on that issue. Animals cannot own property in Texas. However, the Texas law allows a person to create a trust to provide for the care of animals who are alive during the lifetime of the person creating the trust. So, for example, you could create a trust to provide for Barbarella Beagle and Kitty Galore, but if they have puppies and kittens after your death, the trust cannot be used for the puppies and kittens. The trust can go into effect while the person creating it is alive, or it can be in the person's will to go into effect after the person's death. You can name the trustee to be in charge of making sure the terms of the trust are carried out. The property in the trust must be used for the purposes intended by the one setting up the trust, unless a court determines that the value of the trust property exceeds the amount required for its intended use. So Kitty and Barbarella may not get the benefit of all your millions of dollars, but they can be provided for. From a monetary standpoint, Texas law does not value animals highly. Damages for death of an animal caused by another person is limited to the market value, or if market value is difficult to determine, then to the value of usefulness and services provided to the owner. No matter how attached we are to the animal, how much we consider Mr. Meowgie or Spaniel Boone to be a member of our family, we can recover nothing for emotional distress or loss of companionship. In a case involving negligence resulting in the death of a dog, even though the court acknowledged that people have an emotional attachment to dogs and other animals, citing a report found that 70% of pet owners thought of their pets as family members. That decision still stands in the law in Texas. And in that opinion, the Supreme Court did kind of say, legislature, you can change that, you can change the law on this if you want to, but in the 12 years since that decision, the legislature has not taken that action. I'm going to say a little about service animals and emotional support animals. This can be a complicated subject because there are different laws dealing with housing, various types of transportation, workplace, and establishments open to the public. It can take hours to cover the details of this topic, but I want to touch on it since we see more and more animals, especially dogs, in places where normally we would not have seen them in the past. For some of the federal laws to apply, the animal owner must have been diagnosed with a physical or mental disability. An emotional support animal, a service animal, is one that has been specifically trained to perform a task related to the owner's disability. An emotional support animal is one whose mere presence provides comfort or support. No training is required for an emotional support animal. The Air Carrier Access Act has rules for plane travel. You have the right to bring your service animal, but not emotional support animal, with you into the passenger area. An airline may allow an emotional support animal, but is not required by the statute. The service animal, which must be a dog, must fit on the owner's lap or at the owner's feet and must not pose a risk to the health or safety of others or disrupt others or the flight. The Americans with Disabilities Act, or ADA, deals with rules for service or emotional support animals in other situations. For public accommodations, that is, places open to the public, such as a restaurant, store, hotel, theater, etc., a disabled person cannot be denied the right to be accompanied by their service animal. In this part of the law, a service animal can be either a dog or a miniature horse. That's the other species. A dog must be on the leash. The owner of the service animal can only be asked what his or her disability is and what task the service animal is trained for. Can't go into other questions. Another part of the ADA deals with ground transportation, and yet another section deals with ships and boats. In both of these cases, only a dog can be a service animal. With regard to ships and boats, these can be a right, there could be a right to bring on an emotional support animal under some circumstances. The ADA rules for animals in the workplace apply to businesses with 15 or more employees. In this part of the ADA, both service animals and emotional support animals are covered. Any species of animal can qualify as a service or emotional support animal under this part of the ADA. The employer must allow the animal unless it causes undue hardship to the employer. The employer may ask for documentation and a medical exam. Another federal law is the Fair Housing Act. This law applies to landlords, homeowners associations, and others. The FHA uses the term assistance animal to include both service animals and emotional support animals. The Fair Housing Act requires a housing provider to allow a reasonable accommodation involving an assistance animal in situations that meet the following conditions. A request was made to the housing provider by or for a person with a disability, and if the disability and disability-related need for the animal are not apparent, then the request must be supported by reliable disability-related information if the housing provider requests such information. I want to emphasize 2 points. The person seeking the housing must have a disability, and he or she must make a request to have the assistance animal stay there. There are exceptions to the right to have the assistance animal if the housing provider demonstrates one of the followings, and the burden's on the housing provider to demonstrate it. Things like undue financial and administrative burden, fundamentally altering the essential nature of the housing provider's operations, or that this specific animal would pose a direct threat to the health or safety of others, or result in significant physical damage to property of others. Another provision in that law is that the housing provider cannot charge the disabled person a pet deposit for the assistance animal. There are also Texas state laws regarding what are referred to as service animals and assistance animals. Those terms are defined in the Texas Human Resources Code as a canine that is specifically trained or equipped to help a person with a disability and to be used by a person with a disability. So the Texas law only applies to canines, generally dogs, but I suppose it can be argued that wolves, foxes, and dingoes qualify. I doubt you'll find many of those other species serving assistance or service animals in Texas. And I bet some of you, like me, can't hear the word dingo without thinking of maybe the dingo ate your baby. So the Human Resources Code goes on to say that a disabled person has a right to be a passenger in various forms of transportation with their assistance animal and cannot be charged an additional fare. Also, they cannot be denied admittance to a public facility. The definition of public facility includes lots of examples, such as a government building, retail establishment, office building open to the public, restaurant, etc. Now, a word of warning. What happens if someone takes an animal someplace and falsely claims that it is a service animal? The ADA does not address this, but the laws in some states, including Texas, do. In Texas, a person making a false claim can be fined up to $1,000 in order to perform up to 30 hours of community service. But what about that 5-year-old boy who fell into the gorilla enclosure? His name, if I pronounce it correctly, was Vaughn Merritt. There's another key figure in this event, a 7-foot-tall silverback gorilla named Yambo. While other gorillas looked on, Yambo protected Vaughn by getting between him and the other gorillas and gently stroking Vaughn. Eventually, human rescuers were able to reach Vaughn and lift him out of the gorilla habitat. Vaughn was hospitalized for 6 weeks. After his release, the family was invited back to the zoo, and Vaughn has returned many times through the years. Yambo, who Vaughn calls his guardian gorilla, died in 1992. Later that year, Vaughn cut the ribbon at the installation of a bronze statue of Yambo at the zoo. Yambo served human need on that day in 1986, and as our covenant says about this church, service is its prayer. Thank you for listening, and have a good rest of your day.
I don't know about you, but I'm wording a strongly worded letter to Greg Abbott about the status of emotional support miniature horses already in my mind. Get ready.